Hammurabi's Code. Nearly 38 centuries ago, a Babylonian king placed hundreds of legal judgments on a towering stone monument. Why did he do it? What did those laws actually say, and was the result fair? Our story begins in ancient Mesopotamia, a region in the Middle East located mainly in what is now Iraq. The name means roughly land between the rivers, referring to the Tigris and Euphrates. Long before Rome, classical Greece, or the United States existed, people here built cities and organized farming around river water. That geography made food and urban life possible, but it also made control of land and water a constant source of disputes. Mesopotamian society was not a collection of isolated villages. People lived in cities, maintained irrigation systems, traded goods, kept written records, borrowed money, bought property, married, inherited wealth, paid workers, and brought disputes before judges. Every one of those activities could create conflict. A loan might not be repaid. A canal might flood a neighbor's field. A contract might be denied. Complex city life therefore needed regular ways to decide who owed what to whom. Babylon was one important Mesopotamian city. When Hammurabi became its king around 1792 BCE, Babylon controlled a fairly limited territory in central Mesopotamia. During his long reign, warfare, alliances, diplomacy, and administration greatly expanded Babylonian power. Imagine combining many smaller schools, each with its own customs, under one principle. The analogy is not exact, but it shows the governing challenge. Expansion made justice a larger problem, so presenting himself as a ruler who could establish order became increasingly valuable. The stele advertised that royal claim, although historians debate how closely everyday courts used it as a uniform rulebook. Hammurabi was the king of Babylon from approximately 1792 to 1750 BCE. He was not merely a lawmaker. He was also a warrior, administrator, builder, diplomat, religious leader, and ruler of an expanding state. Near the end of his reign, around 1750 BCE, the famous law monument was carved. Hammurabi wanted subjects to remember more than his victories. He presented himself as a just king who protected society, settled disputes, and kept powerful people from abusing weaker ones. Ancient Mesopotamian kings often claimed that the gods had chosen them to rule. Hammurabi followed that tradition. His authority was political, military, and religious at the same time. He did not present justice as a private hobby or a set of suggestions. He presented it as a royal duty supported by divine order. That claim helps explain both the laws and the monument. If the gods wanted order, then obeying the king's judgments could be framed as supporting the proper order of the world. The object commonly called the Code of Hammurabi is a stele, meaning a large upright stone carved with writing or images. The surviving monument is made of dark stone and stands more than 2.25 meters, or about 7.5 feet tall. Picture a legal document taller than a basketball player. Its size made the king's message physically impressive. This was not a pocket handbook. It was a public royal monument designed to look permanent, authoritative, and difficult to ignore. The stele contains 282 legal judgments as conventionally numbered by modern scholars. They were written in Akkadian, the language used by the Babylonians, with cuneiform signs pressed or carved as wedge-shaped marks. Cuneiform is a writing system, not a language by itself. Many languages could be written with it. The dense columns turn the stone into an archive of disputes and decisions involving fields, homes, families, businesses, injuries, workers, professionals, enslaved people, and courts. At the top of the stele, two figures face one another. The standing figure is Hammurabi. The seated figure is Shamash, the Mesopotamian sun god closely associated with justice. Shamash presents symbols of royal authority. People sometimes say the picture shows the god literally handing Hammurabi the laws, but that is too simple. The scene's stronger message is that Hammurabi's legitimate power to administer justice comes from the divine world and depends on maintaining order. The monument begins with a prologue. Hammurabi praises the gods, names places connected with his rule, and explains why he says he was chosen. According to the text, his mission was to establish justice and prevent the strong from mistreating the weak. In simple terms, Hammurabi claimed that the gods had authorized his rule and charged him with establishing order. That claim gave the judgments a moral purpose while also celebrating Hammurabi as the ruler uniquely qualified to deliver justice. The Stele served two purposes at once. It displayed legal reasoning, but it also promoted Hammurabi himself. A monument praising the king as protector and judge is a kind of royal advertisement. That does not make the legal material fake. It means we should read the stone as politics as well as law. Hammurabi wanted future readers to connect social order with his name, his victories, his gods, and his kingship. The monument makes justice part of his public image. Despite its modern nickname, this was not a complete statute book covering every possible case. It is better understood as a collection of model legal judgments. Most entries use a repeated conditional pattern. If a particular situation occurs, then a particular consequence follows. The 282 entries therefore resemble hundreds of ancient what-if examples. They reveal a royal vision of just outcomes, but historians debate how directly courts use the stele in everyday decisions. The subjects are astonishingly broad. The collection addresses false accusation, judges, theft, land, crops, canals, loans, interest, debt service, contracts, merchants, wages, rented animals, marriage, divorce, dowries, children, inheritance, adoption, injuries, doctors, builders, property damage, enslaved people, and court procedure. That range is the first clue that Hammurabi's code is about far more than punishment. It offers a cross-section of what Babylonian households and officials bought, feared, owed, built, inherited, argued about, and tried to protect. Court cases required more than a loud accusation. The laws repeatedly mention witnesses, written documents, sworn statements, and judges. False accusations could bring extremely serious consequences. Under Law 5, a judge who issued a written decision and then improperly changed it through his own wrongdoing could owe a large penalty and be removed from office permanently. The system was not an independent modern judiciary, but it expressed an important principle. People administering justice were themselves expected to follow recognized procedures. The most famous judgment is Law 196. In essence, if one man destroyed the eye of another man of equal standing, his own eye was to be destroyed. Nearby laws address broken bones and knocked out teeth. Scholars call this principle lex talionis, the law of retaliation. The phrase, an eye for an eye, is memorable because the consequence mirrors the harm. Yet that slogan leaves out two essential points. Matching retaliation could place a ceiling on the response, and even that rule varied sharply by social rank. Lex talionis linked the legal consequence to the injury instead of leaving retaliation open-ended. In that sense, it could place a ceiling on the response. An eye for an eye, not more than an eye. We should be cautious, however, about claiming that this was Hammurabi's stated purpose or that it ended private feuds. What the text clearly shows is a prescribed, corresponding consequence, and the next judgments show that correspondence applied only among people of equal status. Here is the crucial catch. Laws 196 through 201 assign different consequences according to social rank. An injury to an equal high-status man might require physical retaliation. An injury to someone of lower standing might require a money payment instead. If an enslaved person was injured, compensation could be paid to that person's owner. Hammurabi's system did not declare that everyone had equal legal value. It recognized ranked categories, and the victim's position helped determine what the injury was considered worth. The hierarchy did not stop with the injury laws. Status also shaped medical fees, compensation, punishment, family authority, and professional payments. Free people themselves did not all hold the same rank, while enslaved people remained legally controlled by owners. Social hierarchy was therefore not an accidental flaw outside Hammurabi's system. It was built into the judgments and helped determine whose loss mattered, who received payment, and who could be punished. Modern readers are often shocked by the range of punishments. The collection includes execution, drowning, burning, mutilation, cutting off hands or ears, forced labor, financial compensation, and repayment worth many times the stolen property. Theft, certain sexual or family offenses, and serious professional failures could bring severe consequences. We should not pretend this was a gentle legal system. Still, violence is not the entire collection. A large share concerns money, land, contracts, wages, crops, households, and compensation rather than bodily punishment. The builder laws are easy to remember. Law 229 says that if a poorly built house collapsed and killed its owner, the builder was to be put to death. Law 230 says that if the owner's son died, the builder's son was to die. If property was destroyed, the builder had to replace it and rebuild the house at his own expense. The familiar idea is professional responsibility for dangerous work. The profoundly different idea is punishing an innocent relative for someone else's failure. Physicians also appear in the judgments. Successful treatment brought set payments, and the amount could depend on the patient's social position. But Law 218 prescribed cutting off a doctor's hands if a serious operation caused the death or disastrous injury of a high-status man. Again, the underlying idea sounds familiar. Trained professionals are responsible for the quality of their work. The method of punishment does not. Modern malpractice systems usually use licensing, investigation, and financial damages rather than physical mutilation. One judgment concerns an ox already known to attack people. If its owner knew the animal was dangerous, failed to restrain it, and the ox killed someone, the owner could owe compensation. This rule matters because it is not simply about an intentional attack by a person. It is about knowledge, carelessness, and responsibility for something under your control. The reasoning feels recognizable today. When you know that your animal, machine, or property creates a danger, ignoring that warning can make you legally responsible for the result. Mesopotamian farming depended heavily on irrigation from the Tigris and Euphrates river systems. Canals and dikes directed water toward fields, but poorly maintained barriers could send water across a neighbor's barley crop. Laws 53 through 56 address this problem. A person whose negligence caused flooding could be required to compensate the farmers whose crops were destroyed. The dispute sounds ordinary. Your water ruined my field. Yet in a grain-based economy, it could threaten a household's food, income, rent, and ability to repay debt. Debt could place an entire household's freedom at risk. If an obligation went unpaid, the debtor, or a wife, son, or daughter, might be compelled to work in the creditor's household. Law 117 placed a limit on certain forms of this debt servitude. Service lasted 3 years, with release in the 4th. The rule did not abolish debt servitude, and the loss of freedom remained severe. But it prevented that particular obligation from automatically becoming permanent across the debtor's family. The collection could also recognize disaster. Under Law 48, if a storm destroyed a debtor's crop or the field failed because there was not enough water, certain payments could be suspended for that year. This did not erase every debt problem, but it acknowledged that a farmer might fail because of conditions beyond his control rather than laziness or fraud. Alongside the severe penalties, this rule shows an effort to keep an unavoidable agricultural disaster from immediately becoming a financial catastrophe. Babylonians were serious record keepers. The laws repeatedly emphasize contracts, receipts, witnesses, sworn statements, and sealed tablets. Laws 122 and 123, for example, concern valuables given to another person for safekeeping. A later claim became much harder without witnesses and a contract. That tells us Babylon had a sophisticated economy involving merchants, agents, loans, rented land, hired labor, transport, storage, and property transfers. Written proof helped turn a private disagreement into a case that judges could evaluate. Babylonian society was patriarchal, meaning men generally held more political, family, and legal power. Some rules concerning adultery, sexuality, marriage, and family honor were extremely harsh toward women, yet women were not without recognized claims. Laws discussed dowries, property, inheritance, divorce payments, child support, and protection from certain debts. Under specified conditions, a seriously neglected wife could take her dowry and return to her father's household. The accurate picture is unequal but complicated. Women could make certain legally recognized claims within a system that gave men greater power. Slavery was an accepted institution in Babylonian society. The collection discusses enslaved people who escaped, were bought or sold, were injured, married, had children, denied a master's claim, or were claimed by another owner. The laws recognize enslaved people as human participants in legal situations, yet also treat them as controlled property. Law 282 says that an enslaved person whose denial of a master's claim was rejected could have an ear cut off. Regulation did not create equality. It organized a profoundly unequal institution. Evidence could come from documents, witnesses, testimony, and oaths, but religion also entered courtroom procedure directly. Under some judgments, an accused person faced a river ordeal. The person entered or was thrown into a river, and the result was treated as a sign from the divine world. Survival could support innocence. Because Babylonians did not separate religion, government, and law as many modern systems do, divine judgment could function as legal evidence. That same overlap between religion and royal authority also frames the monument's overall structure. The whole monument can be divided into three broad sections. First comes the prologue, where Hammurabi praises the gods, presents his accomplishments, and explains his mission. Next come the legal judgments in repeated if-then form. Finally comes the epilogue. Hammurabi again calls himself a righteous king, says he protected people and settled disputes, and warns future rulers not to alter or destroy the monument. The beginning and ending frame the same claim. Hammurabi is the king who brings justice. One major misconception is that Hammurabi invented written law. Mesopotamians had recorded laws centuries earlier. Ur-Nammu's collection dates roughly to 2100–2050 BCE. Laws associated with Lipitishtir date to about 1934–1924 BCE, while the laws of Eshnunna also belong to the period before Hammurabi. His achievement was not being first. His collection became extraordinary because it is unusually large, detailed, visually impressive, and well-preserved. Hammurabi is famous because the surviving monument lets us look deeply into legal thought almost 4,000 years ago. It records far more than dramatic crime and punishment. The judgments reveal what Babylonians farmed, rented, stored, sold, borrowed, inherited, built, feared, valued, and argued about. Archaeologists did not discover the first rulebook in history. They discovered an enormous, nearly complete royal law monument. Its preservation turned Hammurabi into the name most students associate with ancient Mesopotamian law. The stone did not remain in Babylon. Many centuries later, during the reign of the Elamite king Shutruk-Nahant around 1155–1160 BCE, the stele was carried away to Susa, an important ancient city in what is now Iran. It was war booty, a trophy taken from another kingdom. The move explains why modern archaeologists found a Babylonian law monument far from Babylon. It also gave the object a second political life. One ruler's proud statement of power became another ruler's captured prize. For thousands of years, the monument disappeared from known history. In 1902, French archaeologists excavating at Susa discovered the Great Dark Stone. Scholars recognized its cuneiform writing and quickly understood its importance. The stele went on display at the Louvre Museum in Paris in 1904, where it remains one of the museum's most famous ancient objects. A royal message created around 1750 BCE had traveled through conquest, burial, excavation, translation, and museum display into the modern classroom. Was the code fair? Some features answer problems that legal systems still face. It tried to make outcomes predictable. It recognized written contracts and witnesses. It punished some dishonest judges. It assigned responsibility to negligent builders, doctors, farmers, and animal owners. It sometimes limited creditors and protected resources connected with wives, children, or struggling debtors. Those similarities do not make Babylonian law modern, but they show that people were already wrestling with evidence, agreements, professional responsibility, careless harm, and limits on private revenge. By modern standards, major parts of the system were deeply unjust. People were not equal before the law. Social rank changed the punishment. Slavery was legal. Men held greater power than women. Some innocent relatives could be punished for another person's actions. Mutilation and execution appeared frequently, and a river ordeal could decide guilt. Calling the system wonderfully fair ignores these facts. Calling it only random cruelty also misses its contracts, procedures, and limits. It was sophisticated, organized, harsh, and unequal at the same time. The deepest idea is larger than an eye for an eye. A complex society needs an established process for deciding what happens when people injure one another, damage property, break agreements, fail at professional work, or cannot repay debt. Hammurabi's answer placed the king, judges, witnesses, documents, legal customs, and recognized consequences between a dispute and unlimited private revenge. Hammurabi's monument does not begin a straight line toward modern law, and its judgments were neither equal nor humane by modern standards. It shows one ancient royal attempt to channel recurring conflicts into recognized, publicly stated patterns of judgment. Place the story in order. Ur-Nammu's collection dates to about 2100–2050 BCE. The laws associated with Lipitishtir and Eshnunna also predate Hammurabi's monument. Hammurabi became king around 1792 BCE and ruled until about 1750 BCE, near the time when the famous stele was inscribed. Around 1185–1160 BCE, it was carried to Susa under Shutruk-Nahon. French archaeologists found it there in 1902, and the Louvre displayed it beginning in 1904. The stone's fame depends on both ancient creation and modern rediscovery. Memory lock. Hammurabi ruled Babylon from about 1792 to 1750 BCE. Near the end of his reign, a towering stele recorded 282 Akkadian judgments in cuneiform. The famous eye for an eye rule aimed at proportional retaliation, but penalties changed with social rank. The collection covered courts, property, farming, debt, contracts, family life, professions, injuries, and slavery. Earlier Mesopotamian law collections already existed. The stele was taken to Susa, rediscovered in 1902, and displayed at the Louvre from 1904. Knowledge check. Where and when did Hammurabi rule? Think about it. The answer is, he ruled Babylon in Mesopotamia, mainly modern Iraq, from about 1792 to 1750 BCE. Knowledge check. What kind of object contains the famous judgments? Think about it. The answer is, a dark stone stele more than 2.25 meters, or about 7.5 feet tall. Knowledge check. What do the top figures represent? Think about it. The answer is, Hammurabi stands before Shamash, the sun god linked with justice, who presents symbols of royal authority. Knowledge check. Why is code not a perfect modern label? Think about it. The answer is, the text is better understood as 282 legal judgments or case examples, usually written in if-then form. Knowledge check. What did an eye for an eye mean, and did it apply equally? Think about it. The answer is, it linked the legal consequence to the injury, but consequences varied sharply according to social rank. Knowledge check. Name 2 everyday subjects covered by the judgments. Think about it. The answer is, possible answers include farming, contracts, debt, wages, marriage, inheritance, doctors, builders, property, or dangerous animals. Knowledge check. Was Hammurabi's collection the first written law collection? Think about it. The answer is, no. Earlier Mesopotamian law collections include those associated with Ur-Nammu, Lipitishtir, and Eshnunna. Knowledge check. How did the stele reach the modern world? Think about it. The answer is, it was taken to Susa as war booty, rediscovered there in 1902, and displayed at the Louvre beginning in 1904.